Is it on? Do we just? Okay, so we might make a start. Thank you very much for attending, everyone, including the people online and everyone who's here today. My name is Elena Marchetti. I'm a co-director of the Disrupting Violence Beacon, and this is Patrick O'Leary. I'll let you. Another.
I'm a fellow co-director with Elena, and Elena's from the law school, and I'm also from the social work discipline. And we also have, I think there's around 44 people online and about 20 or 30 here in the room. We'll get underway and introduce people. Our guest Commissioner Anne Hollonds, the National Children's Commissioner, is also online. Just giving you the heads up and when you're available, and I'll pass back to.
Thank you. I want to start by acknowledging the traditional custodians of the land upon which everyone is situated here at Logan and as well online, and pay my respects to elders past and present, including extending that respect to any Aboriginal and Torres Strait Islander people who are with us today. And acknowledge that the topic we're discussing today is obviously very pertinent for Aboriginal and Torres Strait Islander people here in Australia because of the disproportionate representation of young people, Aboriginal and Torres Strait young people in our detention centres, and just what the process of and history of colonisation has done to Aboriginal and Torres Strait Islander people, you know, and First Nations people everywhere. So as Patrick said, we have a panel here with us today, including our National Children's Commissioner who, Anne, if you're listening, you might want to turn on your, just so people can see you, your video. Yeah, there she is, waving from afar. We want to say thank you very much, Anne, for joining us today because she is in a jurisdiction where there's a public holiday. So Anne's giving up her time to do this very generously, and we very much appreciate it because it's just wonderful to have you here together with the other three panellists. And they are over here to my left. We've got Dr. Robin Bloor, who's from the law school here at Griffith University and the director of the Innocence Project. Thank you very much, Robin, for joining us on the panel. We've got Catherine Hayes, who is maybe familiar to many of you as CEO of the Youth Advocacy Centre here in Queensland. Thank you so much again for joining us on this panel. And also Charlotte Beaumont-Field at the end there, who is the Sector Development Officer for Human Rights at the Queensland Council of Social Services. And thank you so much, Charlotte, for also joining us. So we've got a really fabulous panel to talk to us today on this topic of justice with children. So what we'll start with, so maybe we'll go to the next slide, Yudi, who's down the back there. So Patrick and I are just doing a brief introduction before we hear from our wonderful panellists on our thoughts about this topic. And we're speaking about this topic based on the fact that we've just actually attended we had, the pleasure, and we're very fortunate to have been there in person, the 5th World Congress on Justice with Children in Madrid. It was an incredible conference, actually, and very well attended from, with people from all over the world, representatives from all over the world, and quite an esteemed, list of attendees. We were just, I can only speak for myself, and Patrick will talk in a moment, but I was quite, overwhelmed by the dedication of people who attended the conference in ensuring that children, we could discuss the fact that children should have better access to justice and trying to work together to achieve that. It was absolutely a conference that I'll never forget. But just some key observations if we go to the next slide. I hate to say it, but what was loud and clear is that justice systems are not working for children. They're quite, not reflective of what children need in terms of justice systems. The clear message was that we need to not only listen to children, but involve them in coming up with solutions and addressing what is going on. And I should point out that the reason why the conference or the Congress was called Justice with Children, that was a purposeful, use of the word with rather than for. And there was quite a lot of discussion about the fact that that's recognising the fact that we need to work with children, not for children, which is what we tend to do. There was a very large presence of children at the Congress, including assisting with, facilitating discussions, including plenary sessions, which was so amazing to see. And they had some interesting things which we'll quickly report today. It's not only to do, however, with the juvenile justice system that, there are problems. Child protection is a problem across the world, as well as acknowledging the fact that civil systems also don't, address or aren't properly structured so that children can access what they need through civil claims as well. Having said that, and Patrick will speak a little bit more about this, we did hear some positive stories. There are countries that are decommissioning juvenile detention centres and moving to different approaches, which is fantastic. I wish we could listen to them and adopt some of those approaches. What we heard, particularly from the young people who spoke, was that the justice system is not only problematic for particularly the criminal justice system for those young people appearing because they may have done something wrong, but also the young people who are appearing as witnesses as well. And there was a very moving story by the first young person that spoke about her experience of supporting a friend of hers who had been raped by a fellow peer at a school, and just how traumatising even appearing or supporting her friend as a witness was through a criminal justice system process, and how at the end of the day she felt, traumatised and really uncomfortable in the system. It was interesting to hear though that the young person who committed the, crime, the offence, was punished and sentenced to some time in a juvenile detention centre. But this young person, what I found really incredible was that she said she didn't feel she didn't feel satisfied when she heard that. She wasn't happy about that. She knew that young person and knew that he had also, complex needs and that wasn't the right way to address what had happened, even though he or she was supporting her friend and, obviously recognised the harm that had been caused to her friend as well. So, it's really, when you think about young people themselves can see the complexity in these situations. They're not, binary. They're not, young people don't see it as either a right or a wrong. You wonder, why is it that we can't adopt that approach, obviously. There's an increasing lack of trust in the system, mainly because young people don't feel that they, are seen and also heard, which obviously is problematic. And the United Nations Convention on the Rights of the Child, the CRC, is there, and it's there for countries to adopt and use in their approaches. But unfortunately, there's a lot of non-compliance, although there is movement, particularly with the general comment number 27, to recognise that there should be alternative methods for some sort of innovative or approaches that sit outside of the formal system, whether that be civil or criminal system, and the need to move ahead with thinking about what would be better for young people. So I'll hand it over to Patrick now.
Yeah, if we could have the next slide, please. Thanks, Elena. Yeah, just moving on to that theme, General Comment 27 makes a range of comments about children's access to justice, and this is an ongoing challenge globally, and even how children receive justice within systems, such as child welfare systems, which are often centred at more of a statutory level than what the child is seeking in terms of a justice outcome for them or appropriate methods of appeal. And this was seen in education and health services, and more broadly, the political participation of children in our systems and decision making. There was a lot of discussion about the fact that we've moved from, in the child participation format, from trying to create child-friendly systems that are still somewhat tokenistic in their approach about what child-friendly means, to rather than moving towards child-centred approaches, where children are active participants in the process. They're the focus of decisions, jointly made, collaboration, and they also have the capacity to initiate issues that they see of major concern, rather than adults dictating the entire agenda. And what we really saw, and Eleanor's covered this, children's voices are often much more informative than adult voices on their experience of justice systems and the outcomes. And really picking up on this is both the experience of people who have offended or may be in trouble with the law, but also victims coming together. And there was a really strong emphasis on progressive programs of restorative process, of ways that practical justice could be delivered simultaneously to both victims and offenders. I think Elena has a couple of quotes here that were really...
So there were a couple of young people that, what they said really resonated with me. So one who was called Lux, she said, or actually they're non-binary, so they said, if we don't want a society that kills, then don't kill children, which seems obvious, right? But it was just, if we don't want children to be abused, then don't have a system that abuses. If we don't want people to commit crimes, then have systems that rehabilitate. And another young person called Elena said, real justice begins before the justice system. It begins when all their rights begin. It must offer paths for young people for the future. We need a justice system that sees children as stakeholders. And what this young person said was they are demanding dignified justice. So that there also needs to be a recognition that not all children are not a homogenous group, and they're very, individual within each of themselves. And one of the other things I just want to quickly mention is there was a very strong denunciation and of what's happening in Palestine. One of the ministers for Spain actually stood up and said it's genocide, and there was, unified agreement in that. And it was a strong message about that.
And as Australians there, we did have a sense of embarrassment and shame that, particularly coming from Queensland, that we are moving towards a backward step, not based on evidence, in terms of the criminalisation of children and institutionalising children. And, we did draw some hope on some countries. For example, we did hear a presentation from Colombia, where they're actually decommissioning child detention institutions. And there's other examples, particularly in the South American countries, but in other places in the world, taking a step. What's interesting there I think, is many of those countries taking a step towards more progressive reform were actually lower income countries, who are, also noting that the cost of these sorts of institution and punishment models are actually really high and really ineffective. Could I have the next slide, please? So, a lot of young people and presenters spoke about the issue of technology, both as in a double-edged sword, the threat of technology, the threat of online media, social media, how quickly that moves, how that people are experiencing injustice, and particularly young people and children online, but it also can be a solution. There was one presentation that talked to the way that young people can participate in court and justice processes using digital technologies where they don't feel confident presenting in person or in the formal way, but making inputs through their digital sort of literacy that they can participate, particularly neurodiverse people. Climate change was a particular issue and how it disproportionately affects children. And Elena just mentioned Gaza and the conflict and the global crisis, but the lack of attention to children's right to life in global and military conflict that's occurring around the world. The lack of attention to speak out about these issues at an international level. And there was also a theme, and one of our colleagues, Susan Harris-Rimmer, also spoke on this at the conference, about the urgent need in how we conceptualise rights for future generations with the ongoing impact of climate change, resulting in lasting environmental harm and increasing disasters, and the justice rights of people in future generations that we have a responsibility to. There was also some discussion about the awareness of rights is not enough, and I used one quote from a child in Lebanon that in some research where he says, "I know my rights, but I want them." And we get some really clear messages from children and moving forward about our responsibilities. Oh, the next slide, please. Yeah, sure.
Yeah, someone will
do it.
You're right. Thanks, Owen.
Thank you. Something that was picked up in a number of sessions is the fact that in many places around the world, including Australia, a lot of children do not encounter the justice system in a formal sense administered by the state. But there's a lot of informal justice systems based on customary systems and informal justice actors. And that these systems offer some caution, but they also offer some hope in that they can deliver progressive outcomes, restorative outcomes, therapeutic outcomes, but they can also be catastrophic in terms of sometimes the rulings made where we haven't really engaged with those informal systems about the rights of children, the issues of gender, the issues of sexual violence and gender-based violence. And this requires urgent research. And we particularly are conscious too of justice systems that were in Australia before colonisation that actually had a lot of merit in process and how justice issues were resolved. And there's a great capacity to increase non-state systems to be child-centred and work in partnership with state-based justice systems and some hybridity, and even considering in the Australian context how communities may respond to justice issues with children can lead to some possibilities that haven't been fully explored. So Happy for us to, that's where Eleanor and I'll finish. There's some contact details there if you want to engage more. And also the World Congress has a website, and we can send that out in email follow-up after today's event. So it's with great pleasure that I'll pass the microphone, or the floor, as people would say in Madrid, to Anne Hollonds, who's the National Commissioner for Children in Australia. And we're so grateful to have you, Anne.
Thanks so much, Patrick, and hello, everybody. Fortunately, I can't see the audience. I can only see the panel, but I'm imagining you in the room and online. I'd like to really thank you for this opportunity. Well, I'm just going to call up my notes so I don't get lost. So I'm joining you today from the Camaragal lands, and I pay my respects to the elders here and to all First Nations people participating today as well. Thank you for this opportunity to share some findings from our report tabled in the Australian Parliament last year called Help Way Earlier, How Australia Can Transform Child Justice to Improve Safety and Wellbeing. And it was just great hearing your reflections, Patrick and Eleanor, on the conference you've just attended. And just a quick reflection on that. I always find it interesting when you go to international forums that the human rights of children are central in the considerations of many other countries in the world. Whereas in Australia, we hardly ever hear children's rights mentioned, certainly not in question time in Parliament or on news bulletins, unlike other issues like women's rights and consumer rights and renters' rights and so on, workers' rights. What we see here in contrast is the rights of children are ignored or deliberately breached, as we'll hear about in this panel. And in fact, we have gone backwards recently in Australia. Child justice is about the human rights and wellbeing of children in the most vulnerable of circumstances. In the past few years, Australia's failure to protect the human rights of children has been internationally condemned. We've seen that from UN committees. We've heard it in global conferences where Australia has been named and shamed publicly, and other bodies like Human Rights Watch World Report that pointed out Australia's human rights record has gone backwards and specifically mentioned child justice. Children in the most vulnerable of circumstances, including many in the child protection system with the state already as their guardian, they are being criminalised, as you know, from the age of 10. And the outdated child protection systems are overwhelmed with unmet needs. Significant systems reform is required to protect our most vulnerable children. So it's clear from our findings that the justice systems are failing to reduce crime by children. Why? Because justice systems can't address the underlying factors that are causing crime by children. You see, crime by children is a symptom of underlying issues and unmet needs that we're failing to address. What we need is evidence-based reform in the early warning systems that are meant to help children with complex needs and their families, including health, education, and social services. Harsher and more punitive justice responses simply don't work as a deterrent. We know that children who come into contact with the criminal justice system at a young age, in fact, are more likely to go on and commit more serious crimes. Locking up children does not make the community safer. So, as National Children's Commissioner, I had the privilege to speak with many hundreds of children in the most vulnerable of circumstances over the last 4.5 years. And some of them, in fact, 150 of them were locked up in children's prisons around Australia when I met them, locked up from the age of 10. And their voices are at the heart of the report I had tabled in Parliament. The reason we called it Help Way Earlier is because that's what I heard from many of the children. They said, we need help way earlier. If you're interested in that report, you could just Google Help Way Earlier. It should pop up. at the top. These kids told me that what they need is the bare minimum for what makes a good childhood. They need a safe home, food to eat, clothes to wear, health care, a school and community where they feel they belong, connection to culture and families who can support them. These basics are critical to their well-being and their development. This is what gives them hope, and this is what helps them to stay out of trouble with the criminal justice system. Sadly, the reality is that the systems that are meant to help children and their families, such as health, education and social services, we know they are fragmented, piecemeal and uncoordinated, described by some as mid-last century in their design and not fit for purpose for what seems like an epidemic of unmet needs today. From decades of evidence, we know that these are children with multiple and complex unmet needs, such as learning problems, neurodevelopmental disabilities, mental health issues, drug and alcohol addictions, domestic family, sexual violence, and other family problems. These kids told me that they want to go to school, but they don't feel they belong there. And some don't feel safe at school, so they disengage from school very early, usually in primary school. Many children enter detention with pre-existing disabilities and health conditions that are undiagnosed and untreated because of the lack of services in their communities. Punitive sentencing and treatment in detention, such as solitary confinement, will further traumatise these children. The way governments are approaching this crisis shows a misunderstanding of the problems we're trying to solve. Toughening up bail laws and sentencing leads to more kids being incarcerated. The evidence shows, as I said, that the younger a child is when they get caught up in this justice system, the more likely it is they'll go on to commit more serious crimes, and that's because crime by children is a symptom of underlying issues and unmet needs. Now, I'm an optimist by nature. But one of the things I've unfortunately had to learn in this job is that things don't always get better with time. And alarmingly, the situation in Australia has deteriorated recently. I'll just mention a few things quickly. Of course, the 2 tragic suicides of children in detention in Perth within a year, the Northern Territory lowering the age of criminal responsibility and reintroducing spithoods, and of course, Queensland, which many of you will be across what's happened there. But I'll just mention that the government's official acknowledgement in their own official reports say that they're directly breaching the human rights of children, that the Making Queensland Safer Act treats children less favourably than adults in the same circumstances and therefore directly discriminates on the basis of age, that the Act creates a sentencing system where adults are better protected than children. I'm quoting, by the way, from the report, and that more children will be held in police watch houses for extended periods and will not be protected from, quote, cruel, inhumane and degrading treatment. And look, that last point is particularly harsh from my perspective. These watch houses are the places where I witnessed the most distressing scenes with children, 4 to a tiny cell, no concrete cell, no windows, fresh air, natural light. Some have no shower facilities, no visits from family, no education, rehabilitation, and the police have no training to care for children, let alone children with complex needs of the kind and disabilities like I mentioned earlier. The fact that the people in charge have no training to deal with kids with this kind of trauma is just truly shocking. And these children are not just there overnight, as you know. They're being held there for many weeks because of overcrowding in the detention centres. So the Queensland Act has been condemned internationally, including by the United Nations, as, quote, a flagrant breach of human rights and international law. And in particular, Australia has been called out for the removal of the principle of detention as a last resort for children. I'm advised by international experts that no other country in the world has done this. And of course, now we're seeing other states under a lot of pressure to, quote, do what Queensland has done and we're seeing bail laws being toughened up around the country. So the United Nations Convention on the Rights of the Child requires Australia to ensure that its criminal justice responses are age appropriate, focused on their needs and on rehabilitation and reintegration to the community. And we know that what's happening now is not based on evidence at all and will not make the community safer. The trajectory for children who become involved with crime is entirely predictable and it is preventable. So the Help Way Earlier project began because of the evidence in several jurisdictions that children were being subject to the most egregious breaches of human rights. And 3 weeks after my Help Way Earlier report was tabled in Parliament in August last year, the Senate unanimously voted to conduct the first ever national inquiry into youth justice by the Australian Parliament. Into child justice, as they called it. This inquiry heard compelling and consistent evidence from witnesses, and they've recommended that the next Parliament, so now we have a new government with a really big majority and probably a long time in power, that this new Parliament conducts further review, including into the role of the Commonwealth Government and other issues raised in the Help Way Earlier report. So just in sort of wrapping up, the Help Way Earlier report recommends that we should be working together across the Federation, and that because of evidence that states and territories are not able to turn this around on their own. There are 24 recommendations in total, and most of them are things the states and territories could do on their own, but the top 4 are about bringing everybody together on a task force to work on a 10-year reform roadmap based on the evidence. Many people are shocked to hear that child wellbeing is not a priority for National Cabinet, which is where the Prime Minister and the state and territory leaders work together on issues of national significance. In fact, you won't see children mentioned at all on that list, unlike things like women and women's safety and housing. These were previously considered state and territory responsibilities, but now we recognise the need to work together across the Federation on them. And I believe that, and many others believe that, unless we make child wellbeing a priority for National Cabinet, we're not going to move forward on these issues, and we'll still be here in 10 years having the same conversation. The Youth Justice Ministers don't meet together across the country. We have no Cabinet Minister for Children. You know, all of these things sort of really show that we don't have the accountability mechanisms for children that we have for other people like women and other issues that are addressed nationally. So, you know, I think the Federation structure is one of the barriers which makes reform more complex, but the Federation should not be used as a loophole or an excuse not to act on the evidence. And that is something the UN has condemned Australia on repeatedly, that we tend to do that, and that when there are breaches of human rights in a state like Queensland, we don't hear anything from the Commonwealth Government about that. We need to ensure there are accountability mechanisms to enable evidence-based reform across the Federation. We need to make sure the Federation works for all of us, including for our youngest citizens. Thank you very much.
Thank you, Anne. That was great to hear. You know, you talk about that report and what's going on, and we'll have the opportunity for questions a bit later on. But I'll now hand over to Robin to talk about the history of juvenile justice in Queensland. Yeah. Or actually more broadly too. Yeah. Okay. Thanks, Robin.
Thanks, Eleanor. Good morning. I'm just going to start, I guess, with picking up on something that Anne was just reporting or talking to us about. And this is a press report about 2 boys being detained in a watch house that said they were detained in one of the cells, and there they remained and they cried throughout the whole morning and intermittently through the afternoon and night. The year of this report was 1897. The boys were awaiting trial for stealing a pigeon. The author continued, the punishment, even if guilty, and according to British law they are innocent yet, must have been greater than many a woman beater or hardened thief suffers. If the system is to blame, it is high time that it was recast on a more merciful basis. While I can't cover centuries of juvenile justice reform today, I will touch on several critical issues that I hope might give you new insights into the legacy of contemporary juvenile justice conversations. Current debates about defining children, detaining them in watch houses, and imposing adult time for adult crime are centuries old. They represent enduring challenges rather than modern innovations. So as we look toward transforming justice for or with children in the 21st century, we might keep in mind sociologist Carol Smart's observation that historical work challenges our modern complacencies and arrogance and brings us back in touch with the prolonged difficulties of bringing about social and legal change. I hope this historical perspective helps understanding both our progress and persistent failures. So taking you back to the early 19th century, the UK Parliament passed extensive criminal procedure reforms in 1826, which abolished the distinction between felonies and misdemeanours. One impact of this reform was to make orchard robberies, or essentially stealing apples, a felony or a serious crime. On the 29th of September 1826, the Chronicle published the names of 7 boys aged between 11 and 13 who had been convicted of this offence. All 7 were sentenced to death, though all were ultimately respited for transportation to Australia for life. In sentencing the boys, the magistrate remarked that he had violated this act 500 times in his youth, and if it had existed during his childhood, half his friends and he would have been transported. Recognising childhood as something fundamentally different to adulthood emerges around this time. There are increasing calls for the law to transform justice for children. In the Tasmanian newspaper in 1836, an article reported on youth crime, noting there are thousands of children who are turned loose every day into the streets to forage for themselves, many whose parents are unable to maintain them and others who are unwilling. Considering the causes of youth crime, reformers recognised that the law itself manufactured criminals, making system reform as crucial as addressing individual delinquency. South Australia, widely recognised as a pioneer of children's courts, began trying children separately from adults in 1891, some 4 years before their children's court legislation was passed. A supporter of this reform observed, "These offences have to be dealt with by law, but it need not put on its most terrifying and sinister aspect. The state manufactures more criminals year by year by its convict system and penal treatment than it knows of. The removing of even the erring little folks from this atmosphere of crime to be dealt with by a common sense tribunal is a departure from ancient custom on which Adelaide is to be congratulated." The shift from a punishment-driven approach to a more merciful one did not come easily, though. Frank Horrocks, a 17-year-old boy convicted of murder in Brisbane's Supreme Court in 1892, was sentenced to death. There was an outcry over the sentence and the refusal by Parliament to commute the sentence to life. Responding to calls for Parliament to be merciful in this case, politician Sir Samuel Griffith said, "If the youth Horrocks were not hanged, it would simply mean that no youth under 18 years of age could be executed for murder." Horrocks was hanged 3 days later. Calls to establish specialist courts focusing on character development and rehabilitation rather than punishment intensified as the 19th century drew to a close. These calls came from charities, philanthropists, politicians, and legal professionals. Women made particularly significant contributions to such reform. In Victoria, the Attorney General was visited by, quote, a number of ladies to ask him to bring in a bill to make better provision for the trial of children. The National Council of Women of Queensland advised Parliament here that at least 25 women's organisations had reviewed the draft Children's Court Bill and provided feedback. Children's Court campaigners nationwide shared similar criticisms of existing procedures and united around a vision for a modern 20th century juvenile justice system. Their central argument was that a mature, progressive society would appreciate the fundamental differences between children and adults. Addressing Queensland's Parliament in 1907, the Honourable Peter Airy observed, quote, it really seems absurd that we have gone on for all these years treating offences of children and those which are practically criminal in the same court. An unidentified parliamentarian replied, quote, we are not civilised yet. The new courts pursued several key objectives. First, protecting children from the stigma of a criminal record. Politicians and the public alike understood that criminal records could permanently damage young lives and future prospects. Second, the physical separation of child offenders from adult offenders in courts, police stations, and custody facilities. Third, protecting children from negative publicity by closing courts for children's matters. This represented a significant departure from common law traditions of open justice, but one that all considered vital to achieve the aims of children's courts. Fourth, appointing suitable members of the bench was desirable, but proved particularly contentious. Politicians argued that highly qualified higher court judges should not handle trivial children's matters. They suggested instead that, quote, a widow of about the age of 50 might be suitable. Finally, regarding punishment, courts prioritised reform and rehabilitation over retribution. Now, when children's courts were introduced in Queensland in 1907, the protection era had been in place for a decade here, largely because of the segregation of First Nations people because of the Act. Indigenous children only began appearing in the children's welfare or justice system from the 1960s. While I can't adequately address First Nations children in the criminal justice system during the protection era within today's scope, nor do I have the cultural knowledge or authority to do so, acknowledging the law's impact on First Nations children demands attention in any reform discussion. So I will conclude with highlighting a 1922 case involving a 13-year-old Aboriginal boy found guilty of murdering his employer's wife in Queensland. The circumstances raised significant doubts for me, at least, about the boy's guilt. Like many young Indigenous boys then and since, he confessed to the crime and the law considered the case closed. Other than this confession, however, there is no direct evidence linking the child to the murder. The boy was sentenced to imprisonment for life with hard labour. The public defender appealed the boy's conviction, arguing the prison sentence conflicted with legislation stating that children under 17 convicted of crimes that were usually punishable by imprisonment could not be imprisoned. Only weeks before the boy's trial, in August 1922, murder in Queensland had carried the death penalty. The court thus faced a complex question here of statutory interpretation regarding how the abolition of the death penalty affected this case. Essentially, what we have here is an adult time for adult crime debate that's over a century old. Queensland's Court of Appeal dismissed the appeal, finding imprisonment was applicable in the circumstances. Outside courtrooms, the Labor Women's Vigilance Organisation approached local politicians urging an alternative sentence. They argued no boy in a normal state would commit such a crime. They demanded no child, again, receive imprisonment for life with hard labour, and called for the boy's return to his community. The High Court subsequently overturned the decision of the Court of Appeal, finding the law that children under 17 could not be imprisoned did apply. 3 weeks later then, the Queensland government passed a law making Palm Island, already designated as a prison, an industrial school, specifically to incarcerate this young boy in what was, for all intents and purposes, a prison. To conclude then, while we no longer execute children or sentence them to transportation for stealing apples or pigeons, and children's courts have become vital parts of our justice systems, many issues that campaigners had fought so hard against over a century ago persist or have worsened significantly. Today's difference lies in having over a century of resources, of research, evidence and experience to inform contemporary approaches to youth crime. Overwhelming evidence now supports what early reformers suspected or speculated about. Significantly, they were prepared to act on their limited knowledge. Considering this historical context makes continued decisions today to overlook the knowledge, evidence and experience of 150 years even more increasingly difficult to justify than they already are. Thank you.
Thank you so much, Robin, for that very insightful, what have we learnt through history insights. It's now my pleasure to introduce Catherine Hayes from the Youth Advocacy Centre, CEO, to talk about the current situation in Queensland.
Thank you, Patrick. Unfortunately, I don't have a light at the end of the tunnel. It continues on in a fairly grim tone, as Robin started with. So the Youth Advocacy Centre is a community legal centre, and we represent kids in the youth justice system here in Queensland. And we also provide wraparound support. So we provide court support, which Charlotte used to provide and has since moved on. So that means that kids that are in the court system have somebody who turns up, explains the system to them, goes down to the watch house or the court cells and explains what's going to happen to them. We also provide social work and youth support to kids in the who are on bail, so help them comply with their bail conditions and get on a better path, and family support and homelessness support. The political environment here in Queensland has meant that it's really hard to get any traction for any kind of humanity for the kids in the youth justice system. So at the moment, they're seen as almost evil, really, with very little nuance in the discussion. So that's resulted in, and where this current situation started from was back in when the awful North Lakes murder took place. And that was an awful, horrific crime, a tragedy that has resulted in a woman who has lost her life, 2 girls without their mother and a husband without his wife. Horrific and should not have happened. And that has meant that that caused the public narrative to become very emotional, and understandably, because it was a crime that caused a lot of fear, a woman in her own home. But what it was part of was a larger debate that was not based on evidence or data. And that meant that we've now got laws that are resulting in the daily abuse of kids' human rights. And it hasn't just started with the adult crime, adult time laws. It started with the Palaszczuk government making the bail laws much harsher. So kids, when in the children's court, when they have bail conditions, they're often quite therapeutic. So it might be you need to attend school, you need to stay home between the hours of X and Y, you need to not hang out with these people, you need to not go in a car unless you're driving with this person. So quite low-level behaviours that aren't crimes. But the Palaszczuk government introduced new laws which meant that a breach of those conditions now became an offence. as a result, we have in the Brisbane Youth Detention Centre, out of about a dozen units, each holding maybe 8 kids, about 3 of these units have kids with significant cognitive impairments in them, because the breach of bail laws introduced maybe 3 or so years ago have resulted in a higher number of kids with cognitive impairments not being able to comply with their bail conditions and then ending up in detention centres. In addition to that, the Palaszczuk government then altered the laws to allow kids to be held in watch houses indefinitely. So the watch house situation in Queensland has just been horrific. It reached a peak a couple of years ago, 2019, and then again in May, I think it was 2022, and again in 2023, when there were almost 100 kids at any one time in watch houses for over 30 days, some of them. And the watch houses are awful. So they are just a cell, sometimes just one bunk in them. In Cairns, it's particularly bad. They have 4 kids in one cell, so they're lying on the floor. They have an open toilet, so just the toilet in the same small room near them. The air conditioning is often up very high, and the guards have traditionally used access to blankets as disciplinary measures. We've also seen examples of access to food used to discipline the kids. And once you've got kids who, even from the most balanced upbringing, in a locked cell with no mental stimulation for days and days at a time, they are going to misbehave. And so that's an inevitable outcome of the situation that they're put into. So then we'd see kids who've had charges arise out of their conduct in the watch houses. And that was just a situation that was going to result from them being put into an adult watch house for a long period of time without any kind of proper supports. There's also in the watch houses been horrific incidents of sexual abuse from cellmate to cellmate because they're packed in cells for long periods of time. We've also seen kids, cellmates beat up other cellmates. There's one young offender from Cairns who has significant mental impairments and a lot of undiagnosed but significant complex behaviours. He's already been in the watch houses for sexual offences and he's only 12. And so when he goes into the watch house, he's beaten up by the other cellmates, the other kids, because he's a sex offender. And this goes on and on and on, time and time again. We get the watch house list every day. I'd see his name come in for about 5 days. He'd go out, he'd come back in. And it's just inhumane to put all of these kids through that kind of circumstance. So when after the Miles government lost the election on the basis of adult crime, adult time, then the new adult crime, adult time laws came in December last year. So that was a handful of offences, and we've seen them coming through the courts in the last few weeks. Cases where kids would have previously received a probation order are now the kids are now getting custodial orders. So this traditionally has been a quiet time of year for the detention centres. They would generally not have many kids held in watch houses this time of year, but today there are 50 kids in watch houses with stays of up to a week in the Cairns watch house at the moment, and then 2 or 3 weeks in the Wakehole Remand Centre. And the Wakehole Remand Centre is billed as a solution to the crowded detention centres, but it is just a really new flash watch house, just cells with, again, very little stimulation, no privacy, and the kids we're seeing them held for up to 3 weeks at a time at the moment. Part of the problem in not being able to get any kind of traction in our advocacy against what's going on in youth justice in Queensland is, first of all, the polarising debate on rights. So we have victims' rights pitted against kids' rights, whether it's seen as it's one or the other, whereas that's not the case. We need to uphold all victims' rights. Everyone that has been the victim of a crime needs to have their relevant rights upheld. And that means to be informed throughout the process about what's going on, to receive compensation if they're entitled to it, to have access to the outcome of the court proceedings. So those rights absolutely must be upheld, but that doesn't exclude the rights of kids to have a safe home, to have access to education, to have proper assessment for the underlying conditions. And most of the kids in the youth justice system have some level of disability, including a massive overrepresentation of fetal alcohol spectrum disorder. most of them are going undiagnosed and untreated. And what assessment does occur in the detention centres doesn't then flow out into the community. In addition to that, the public narrative has gotten to a level where there is an inability to have any kind of nuance in the discussion. So one particular circumstance that I can think of is when the gym in Mount Isa, the community gym, was burnt down. And there was a huge outpouring of understandable anger because this was a community site where lots of families and children and organisations gathered, and it was really important in the social fabric of the Mount Isa community. And there was huge anger at the young Indigenous kids whose conduct had resulted in the gym being burnt down. But one of our solicitors was involved in a bail application for one of these kids. And it is before the courts, but I'm still going to talk about it. She saw the video footage, and it was kids that had broken into the gym one night and they were mucking around. One of them stupidly lit a fire somewhere in the gym. They tried to stamp it out. It got bigger. They tried to stamp it out even further. It gained traction, and they called the fire brigade. The fire brigade came, but the gym burnt down. So that nuance is, and this nuance exists in so many of the circumstances that we deal with, but it's never given. It's just evil kids burning down gym, and the kids shouldn't have done it, and they should receive consequences, and there's a whole lot of things going on there. But in the public debate as it is now, we can't talk about that complexity. It's really difficult for there to be any kind of discussion to the depth that's required to address youth justice. Just one final comment, if I could, is the intersection between the child protection system and the youth justice system, and the lack of housing options for kids who are not in the who are not going to their placements under child safety. So we have quite a few kids who, and the euphemism is they self-place, so they live on the street rather than go to a residential care home. And we have one particular client, and we've got many clients in this circumstance, but one in particular whose story I think really epitomises the awful situation that is taking place at the moment. She drops into our office every now and then to get food vouchers because she's a child safety and has been her guardian for about 4 years, but they won't let her into their offices because she becomes heightened and escalated. So she comes and visits us. They email us a voucher, we print it out, give it to her, and she goes on her way. Sometimes there's a delay and she becomes heightened and aggressive, but she's living under the Grey Street Bridge and she's got nobody. And one day she was in our reception and I could hear her yelling out, "My life is fucked, my life is fucked." And she became more heightened and was self-harming, and our workers called an ambulance, and the ambulance came and picked her up, and then she was admitted into the Princess Alexandra, she was 16, sorry, young Aboriginal, 16, admitted into the PA adult ward, and then she was there for 2 nights. And then Child Safety rang us up and they said, "Can you come and pick her up? Then can you drop her back under the Grey Street Bridge but give her some food vouchers?" And that to me is a real symbol of the crisis that we're in and that we're not tackling. Thank you.
Thank you so much, Catherine. I mean, it just begs the question, what are we doing? And moving straight on from that, and I think this is a great segue, we now have Charlotte from QCOS speaking about human rights and young people. Charlotte, I believe, has some PowerPoint slides, and I think you will just let Judy know when you need them changed. So that's fantastic. So over to you, Charlotte.
Good afternoon, everybody. My name is Charlotte Beaumont-Field. I work as the Sector Development Officer for the Queensland Council of Social Service in the human rights arena. So there are, some of you may be familiar with the Queensland Human Rights Act that was passed in 2019, where I know that there are other people from other parts of Australia who may not be so familiar. So I will discuss it a little bit, but I don't want to be, I guess, too basic with it. So these are for the people who may or may not be aware of the Act. First slide, please. So people may or may not be aware that Queensland has 23 protected human rights. So the situation that is going on at the moment limits a lot of those rights. So, I mean, I can look at a lot of them right now and just, select a couple that are just glaring at me. But what I wanted to point out was that there are particular rights that have been sectioned, have been given their own, right to stand on their own, which is the protection of family and children. We've got the rights of children in the criminal process. So those two rights, they've been developed specifically to try and protect our children. Next slide, please. So we have these are a bit more detail of the rights of the children in the criminal process. In particular, I would like to draw your attention to a child who has been convicted of an offence must be treated in a way that is appropriate for the child's age. So we've gone out of our way to campaign for some legislation in this state to particularly identify the vulnerability of children and that we have this moral need, and it is evidence-based as well as being morally the right thing to do, to protect children in this state. Next slide, please. The Act recognises that children are entitled to special protection. This makes sense. We know this. It recognises that children are more vulnerable because of their age. Again, not brain science, like this is, very obvious. The right to protection of families and children means that the government should adopt special measures to protect children. Next slide, please. So, this is from a report. I think actually James McDougall may have registered for this conference, so I say hello and thank you. But and obviously I'm not going to do the report justice in 10 minutes that I have your attention today, but I wanted to highlight the 3 reasons that are often used for limiting children's right in the youth justice system. So we've got rehabilitation is not a primary focus. Okay, so that's one reason that rights can be limited. I've got a thumbs up, that's good. So media reporting and public attitudes. We know that when certain highly dramatised, particularly heinous events happen, there's a huge media response. Okay, we know that. And that can lead to, very reactive and hasty responses by the government. They're not based on any evidence. And institutional racism. Failure to understand the impact of policies and procedures on certain groups, which can lead to a greater number of children having contact with the criminal justice system. There's often use of the word crisis, and that further pushes the urgency to challenge and limit the rights of children. So as soon as you start banding about, that this, there's lots of different terms going on that you would have heard in the media, throughout many years. I mean, this is a cyclical thing that happens where there's something, the media pounce on a particular crime. I had a couple of my clients when I worked with the Youth Advocacy Centre were some of the young people who broke into the rugby player's house. They were wonderful kids, terrible situation. But I guess what happens from these kind of incidents is that these children become something other than children. They become some evil thugs. They don't, and so it's easier for us, I guess, or the government, sorry, to take away their rights because they're no longer children. Therefore, they no longer have the, have the same rights that are afforded to children. It's easier for us to digest. It's easier for the general public to digest. We take this label of children away and they become these violent thugs, terrible offenders, these, horrific beings that are plaguing our, wonderful state. We can sort of label them like that, then we're able to justify limiting their rights. Next slide, please. This is one such example. Our police will continue to round up this generation of untouchables and send them here to this new facility where they'll be held accountable for their actions. Young people who have been through horrific situations start to not care really where they end up. I've worked with children who don't have beds, have never had a bed. Their first bed was in a sort of a bail house that I worked in Sydney. They didn't know how to make a bed. They didn't understand why you needed to make a bed. Okay, so we have these kids who, and after a while they go to the streets, back to some sort of detention centre, out again. It all becomes some sort of, it's just their way of life, which is extremely sad. And it's not something that imposing harsher penalties is not going to change their way of thinking because they've known nothing different. Next slide, please. So part of the Human Rights Act, there's a section, section 13, which allows for certain human rights to be limited. Under the Act, compatible with human rights means an act or decision does not limit a human right or limits a human right only to the extent that it is reasonable and demonstrably justifiable. So just focus on that. So we've got to, you can limit a human right if you can justify it. Human rights should only be limited after careful consideration and in a way that it can be justified in a free and democratic society based on human dignity, equality, freedom, and the rule of law. Next slide, please. We have this, the Human Rights Act is based on a dialogue model. The three arms of government must consider at every process, whether that's making and changing the laws, putting the laws into action, or interpreting and enforcing the law, they have to consider the human rights that are particularly being engaged with any kind of decision or policy change. Next slide, please. So this wonderful new piece of legislation that we've got in Queensland now clearly limits many rights of a child. We've removed the principle of detention as a last resort and related provisions from the Youth Justice Act from 1992. Principle that a sentence which allows a child to stay in the community is preferable no longer applies. So these are glaringly obvious that these are limiting the rights of a child, which is and these young people who end up in the criminal justice system, we know that they are victims themselves. We know that the atrocities that they have experienced themselves. To remove them further from the community does not assist. It does not make the lives of anybody safer, anybody better. The community want action. They want something that's going to work. Taking away these children for X amount of time, yes, okay, for that period of time, they will not be on the streets doing whatever, but then they'll come back. And they'll come back not better. Next slide, please. So when a human rights is limited, you have to justify it, as I referred to earlier. So statements of compatibility are released. So as outlined in the statement, the Making Queensland Safer Bill of 2024, the bill will expose some young offenders to mandatory minimum sentences of life detention. And as we've discussed as well, that these limitations will make the situation for children far worse than for adult offenders. Impose clear and deep limitations on the right to liberty, that's section 29, and the right of children to protect in their best interests. Increase in custodial sentence will further strain capacity in the youth detention centres and watch houses, which engages section 17 and section 30. And as logically, this may also mean that children are in these horrific situations for longer periods of time. Amendments could have a greater impact on Aboriginal and Torres Strait Islander children who, as we know, are already disproportionately represented in the criminal justice system. So these are things that the government's saying, yeah, we know that this is all going to happen. We know this. Next slide, please. What discourages me more is that there are acknowledged in this compatibility statement, we know that there are less restrictive options available. So we could still, limit the rights of these children, which may appease some of the general community, but we've chosen to not only to go that step further and restrict the human right even more. So we could, if there was an option, we could increase maximum penalties for specific offences, which mirrors the maximum penalties for adult offences, the adult crime, adult time rhetoric that's going around. But we could do that without exposing children to the mandatory minimum sentences. That's an option. I'm not on board with increasing the maximum penalties, but I'm saying that that is an option. And the provision of courts with sufficient discretion to impose a sentence that fits the crime and the circumstances of the offender or child. That's an option. There could be, we give more power to the courts to look at each individual child appearing before the court to have much more discretion in the sentencing of that child. Next slide, please. Again, there's a quote in there from the Attorney General that I would like to read out because I think it's particularly important. While I acknowledge that these amendments are not compatible with human rights, these measures and the purposes to which they are directed are clearly supported by Queenslanders and are a direct response to growing community concern and outrage over crimes perpetuated by young offenders. For this reason, the amendments include an override declaration, which provides that they have effect despite being incompatible with human rights and despite anything else in the Human Rights Act. So these new laws are in direct conflict with international law standards. We know this. We know that internationally we are seen as I can't think of the right word at the moment, but we're not doing the right thing. We're not doing well. The amendments will lead to sentences for children that are more punitive than necessary to achieve community safety. Focus on that. That's just mind-blowing to me. The negative impact on the rights of children likely outweighs the legitimate aims of punishment and denunciation. So we're going that extra 5 steps further to really hammer home that we don't value children. As soon as they commit an offence, which basically all children do, we're really hammering home that they no longer are children in the community, general community's eyes. Next slide, please. QCOS recently submitted the Human Rights Act review submission on the Statement of Compatibility process. Robust systems, processes and requirements must be developed to support the production and operation of statements. Feedback from one of our members recommends that there needs to be a basis for appealing or challenging the conclusions in the statements of compatibility, and also raises whether there should be a mechanism to compel the government to produce the legal advice upon which those conclusions were based. So we've got the Human Rights Act. We've got the ability, if it's justifiable, to limit rights within that act because it is a process. It is based on a discussion model. But then the government can release these statements of compatibility, acknowledging that there's gross breaches of this piece of legislation in Queensland. But there doesn't seem to be any processes in which to appeal that or question that. Next slide, please. Again, I would encourage you to seek out the Putting Children First, a rights respecting approach to youth justice in Australia. James McDougall in 54 Reasons. Again, cannot do it justice, but we know that a child first justice, a rights respecting approach will make Queensland safer. It is morally sound, but it's based on evidence. We know if we take care of people, we know if we treat the underlying causes of offending, we know if we put their rights foremost. And it's, again, as Catherine said, not to discount victims' rights. These two things can exist at the same time. So if we recognise the specific needs of children and young people, we know that it is more effective in reducing crime, which is the ultimate goal. Like, apparently everybody wants the same thing. It provides a long-term solution to offending behaviour. It's an effective way to increase public confidence in the system because you'll see results. And it is more cost-effective than taking a punitive approach. It has always annoyed me that if we focused on more intensive community responses, yes, it costs a bit more, but not nearly as much as it costs locking up a young person. That confuses me. So many things confuse me. But the way forward is a child's rights approach. We must acknowledge that children are vulnerable. They do silly things. They do things in reaction to a multitude of reasons. I mean, I worked with kids who lived in Sydney, you know, but were so disadvantaged. They'd never been into the city before. One gave me an orange once. How do I use this? How do I get into this orange? I've seen it in juice form. So we're talking about children like that as well, that don't know, have never had a bed. Charlotte, how do I make this bed? Why do I need to make my bed? Things like that. We're talking about children who are from really disadvantaged backgrounds, and our solution is to push them further and further away from having a bed, from having, you know, knowing how to, you know, eat an orange. So I think that's all from me. We'll just, yes, that is. Thank you.
That, Charlotte, it just makes me think that what's the purpose of a Human Rights Act when it doesn't actually get applied or do the, you know, we can't use it to actually fix what's happening. We've got Miriam here, who is our research fellow with the Beacon, who will now facilitate this next portion. And I know we're running way behind time, but we'd like to have a little bit of time for questions. So just bear with us. And yeah, maybe Miriam, if you can, you know, sift through the questions and see if there's any online and any from the floor, that'd be great.
Yeah, thank you.
What an amazing discussion, very complex issues that we're talking about. I'd like to invite anyone online, if you want to pop a question into the chat, you're most welcome to. And if you have a question that you'd like to voice, raise your hand in the chat as well, and we can get to you. But first, I guess we'll open up to people in the room. If you'd like to ask a question, Juna here will give you the microphone. And and so while we're doing that, anyone online, you can pop your questions in the chat and I'll get to you as we kind of circle through the questions here. All right, we've got our first contender. And if you'd like to just introduce yourself quickly as well so we know who's talking. And floor's yours.
Try that again. Sorry, Samit Sulman from Griffith University. My first question is around the intersection of criminal justice, children's rights and migration, given that this is, I guess, a global issue where young people's rights are being trampled through the exercise of border control and migration governance regimes. And I was just wondering the extent to which you've, I guess, thought about this intersection in relation to what's happening in Queensland over the past couple of years. The second question has to do with how we map recent changes onto, I guess, an expanding political economy of detention, both in Australia and globally. To what extent do we have to kind of account for the economics of detention in the rather febrile debates around children and youth justice?
Would Anne, you like to answer that question? You on the spot?
Not quite sure. Can I, if the questioner still has the microphone, could you say a bit more about the economics of detention, just so I understand what you're talking about?
Sorry. Yeah, absolutely. Thank you. I guess detention, incarceration is big business globally.
You mean like the private providers of it?
Yeah, absolutely.
Okay, all right.
Yeah. And I think that, the privatisation of detention has expanded significantly in Australia over the past 20 years.
Okay, thanks for clarifying. I wasn't quite sure if you were coming at it broader than that. Look, I think I don't know that we've privatised youth detention in quite the same way in Australia. I might stand corrected on that in some jurisdictions, but I don't believe that's a big issue when it comes to children. There are a lot of other issues as we've heard this morning, but I'm not sure about that one. And your other question was about immigration. I mean, that's there are some very important issues, I agree, about the rights of children in immigration, but I'm just not sure that this morning's panel discussion where we're not so much focusing on that. So, I mean, I'm looking at Patrick and Elena, but maybe that's something that perhaps is for a discussion afterwards. Sorry about that.
Yeah, no, I mean, certainly at the World Congress, migration and the rights of children and also the concept of statelessness came up significantly, where children are not recognised by any state in terms of their migration and immigrant status. Brought up significantly, and as well as the issue of children's rights in refugee and detention centres in migration, where they're not recognised under the country that's holding them laws, and often that also brings about informal and customary justice within that boundary.
Can I just add to that quickly that I know that for the ASEAN countries, that's a really big issue in our region, and they're doing some very focused work on children in immigration detention. And I've attended some of their forums. Of course, Australia doesn't detain children now for under immigration policy, but it's very fragile. You know, like at any moment that could change, and it's something that we absolutely need to keep an eye on.
Great. Thank you for that first question. Yes, we have another one up the back, and then I'll move to a couple of online questions.
Thank you. Terry Hutchinson, I'm an adjunct at Southern Cross, and my question is really about the economics. I'm building on the discussion. I just don't understand why legislation can be passed without a statement of how much it's going to cost. And I think this latest legislation, particularly in Queensland, with the adult crime, adult time, it has a cost. It has a great cost. And I think it has a social cost, but it has a financial cost. There is an economic cost there. Is that, I'm not aware that any of the governments have taken that on board completely, but I would like some comments.
It is interesting point, Terry, because the latest figures from that the Productivity Commission, the federal one, I think, produced shows that detaining a child in a detention centre in Queensland costs $3,000 per child per day, but to provide them with support in the community is in the hundreds of dollars per child per day. So it's definitely not economic. And also the new youth detention centre that's being built at the moment is going to cost almost $1 billion. So there's no financial or economic sense to it whatsoever, but that doesn't get any traction at all. They plough on. So yeah, I agree.
Would anyone else like? No? Okay. We have a question online from Kat Baxter, who's asking about, is it because Queensland has no Senate that they can push through these laws?
Yes, so we go through the parliamentary committee process every time. So instead of the upper house, we've got the parliamentary committee process. It's always the final vote goes to a member of the government party or whoever's in power. And we all make submissions, we give evidence. And the thing that frustrates me is that all of the evidence is treated equally. So I happened to be in Cairns and watched the hearings up there, and a woman was talking about how when she was growing up, she had to eat offal. And so kids these days don't know how good they've got it. And that's given the same weight as Victims Commissioner Beck O'Connor's extremely well-reasoned and evidence-based report and recommendations. So there's so much evidence that goes to these committees and they're given no regard.
I have another question online from Anna Emsley. Apologies if I've ruined your name. So in the discussion of international countries decommissioning detention centres, what were the alternatives that they were finding? And the most recent success in rehabilitation and deterrence of young people from the justice system?
It seemed that the alternatives were very much centred around more restorative and health solutions. So situated within, a health framework, and also that notion of making sure that it was to do with working out what the complexities are and addressing those through a bit of a restorative sort of process. I mean, in other countries, processes are drawing very much from community. So the focus is community-based justice, and not in the way we see it here in the vigilante type of framework. It's more to do with drawing on the knowledge of community members who are often community justice actors, or, I mean, in the presentation I gave, I spoke about the role of elders here in Australia and the role they have in Aboriginal and Torres Strait Islander communities and how much more effective that can be as well. So that they were some of the solutions, which we're hoping with the draft general comment 27 might be, afforded more recognition and I guess more resourcing as well. Patrick, did you want to add to that?
Other than it probably picks up on some of Anne's points about, what are the underlying needs of children that get involved in the justice system? How do we actually get that help way earlier, but also address it when children are presented to justice systems?
And education as well. Education was a large component, like, for example, in Colombia and Egypt as well. Yeah, it's just really interesting that they're recognising, the need for that early intervention.
Can I just jump in there and just also add that there are a lot of, there are other countries like in Europe and the UK that are looking at secure care models, like they're still secure facilities, but they're in the community and they are therapeutic in their focus. Like none of this is, without its issues, but, if there's a general acceptance that some kids will have to be in a secure care facility, that can be done in the community. It doesn't have to be a children's prison.
Yeah, do we have another question from the audience? Yes. We just get the microphone to you.
I think my question was partly answered there. I came along today to hear more about what rehabilitative and therapeutic and community-based responses might be appropriate in supporting both children's rights and community safety. So we touched on some of those elements there. So I did have a listen to that. I think, and I take what Catherine Hayes was saying there about how difficult it is to move the media conversation and have the conversation be more nuanced. And I think that as, I could call ourselves a movement, maybe firming up the frameworks and making clear the exemplars on what the alternatives are might be a way forward to move the conversation forward. Because myself, I'm very interested in the policy space and I want to build up that knowledge and build up those ideas of what we can try. And I hear that it's a difficult, space to have those conversations, but I feel like that's where we need to be moving to say, this is the evidence-based programs that work. This is what they look like. And that gives the media, politicians, the community something to envision. But is there any response to, that idea?
Yes, that I completely agree. I think part of it comes down to we're a sector that everybody is really stretched thin. So to do what you would do, it makes perfect. What you're suggesting makes perfect sense. And I think is the answer. But I think that everyone's exhausted and stretched is probably one of the main things. Yeah, yeah. I don't have anything else to add, actually. It's a good idea.
And can I just add to Catherine's point? We are doing a supplementary report to Help Way Earlier now to do exactly that. So looking at some case studies internationally and in Australia to try to shine a light on other approaches. Of course, you can't do direct comparisons because the context in which these programs are developed are different. Every country has a different welfare system and other differences, but there are some principles you can draw out. And I agree 100% with that questioner that we need to feed these examples of what's working to the media so the public gets the truth, that there are solutions. One of the key barriers is a lot of them don't have what you might call rock solid evaluation data, and particularly in Australia. You go looking for evaluation data on diversion programs or other methodologies, it ain't there. And so we've got to be quite creative about it. And as I said, try to draw out some principles of promising practice and really hammer those home.
And I just want to add one point that certainly comes out and is really highlighted, particularly in Catherine and Charlotte's presentations today, is these issues are intersectional. So, you know, that the impact of domestic and family violence on juvenile crime, or can't be separated, and trauma can't be separated in young people's lives. And we often like to partition these all away, but they, often home is not a safe place to be. And if you can't be home, it puts you in a vulnerable position in relation to the law.
All right. Yep. In the red up the front.
Sorry. Hi, I'm Marilyn Casley. I'm from Griffith University. I teach in the child, youth, and family practice degree here in our school. And first of all, I just want to say that, it is about early, if we don't, early intervention really has to start at birth, because we know how people's brains wire up, and we have 25 years of evidence. And so we also know that under 2 is actually even worse, that kids will take that with them without even understanding what triggers them. And so I think, again, this country, we're still struggling to provide services for children at that age. And sometimes we re-traumatize them every day by putting them in very poor quality services that I see in my work. And it's quite scary what we've seen in childcare recently. But we don't seem to want to do anything about that either. My question is about kids that survive the system, and at 18, are they ready to, have you had cases, I'm probably asking the advocacy center, and I'm sorry, I forgot your name, Catherine. So are there kids at 18 then looking at what's happened and saying, well, I've been a child of the state, under their care, and they haven't given it to me. And would there be a case for those kids to sue, or, is that out there?
So we at the moment, and for the last couple of years, have been looking into a case for a number of kids suing the government in relation to mistreatment in the watch houses and detention centres. I just don't know about failure of care under child safety. I don't know. That's less clear cut, but I think when you're in the detention centre, you're 100% in the control of the government, and so that's pretty clear cut. But yeah, I don't know the answer to that.
No, I just wondered if you knew of any cases.
No, I don't know of any cases. Anne, do you know of any cases?
No, but it's a fantastic idea. It really bothers me that for these kids, the state is their guardian, and then the state becomes their jailer. And, we have to do something about this. It's absolutely abominable what's going on.
Yeah, so I think we've got time for one more question because we have gone over time a little bit. So thank you for your patience. Is there anyone else in the room while we've got you in the room? Otherwise, they've got, yeah. All right. One last question up the back. And thank you for everyone online. And yeah.
Hello,
Go ahead.
everyone. Is it working? Yes. Patricia Lee from Griffith Sustainability. Thank you for the invitation to come. It's been amazing. Really enjoyed it. I have more sort of like an observation. I really like what you were saying about the example of Colombia. So I'm originally from Mexico, and I was wondering, there's a lot that goes into culture. So culturally, for people like Colombia, family is the first thing. Children are very respected. Obviously, I'm not from Colombia, but they have problems with violence, etc. But how much is it a thing, part of the culture here in Australia, for example? Is it something that we're not really prioritizing, the family values and the principles? And would that be something that is leading to this, in your opinion?
Yes.
I recently met with an elder from out at Ipswich area, and she was saying to me that unfortunately, even within the Aboriginal community, where family is often, the core lever for change within, you know, community and also with young people, that respect for elders is decreasing. But we've got to find ways, I think, to make sure that it strengthened, like gets reignited and strengthened. I think one of the other points I want to make, which Anne, you made me think of in your comment, is we've got to be very careful about how we decide, you know, to measure success. I'm always very, I don't know, I tend to really push studies that use different methods, even though they're not the traditional, conventional, statistical, you know, gold star method. There's people within, my background's law, but I also do criminology. I work in the area of criminology, and there's scholars and researchers in that area that will disregard anything other than randomized control trials, for example. And I just do not know how we can, you know, test that. We cannot control for everything that happens in a person's life as they do with a medical intervention. And even in medical interventions, they can't control for everything. And that's been recognised. So trying to do that within a social context is incredibly difficult. And I think we really need to start voicing that opposition to that type of methodology, which has been, you know, the traditional type of methodology that's used to test interventions. And really, we can start by just showing that the current system, you know, doesn't work. It just does not work. And an intervention can be evaluated in different ways. And, you know, I was really heartened recently in Queensland, there was a tender that was put out for, I can't remember what they called it, but stories. No, there was a tender put out to ask for success stories and a study. I mean, I didn't go for it, but I was very pleased to see that, and particularly looking at Aboriginal and Torres Strait Islander communities. But what the government wanted, and I can't believe I'm singing the praises of, but I thought this was actually a positive step, was stories about young people who had successfully navigated outside of the system. And I think even that is, you know, someone else mentioned it, and someone here mentioned that we need to focus on, you know, those sort of stories, and I think it was you actually within the media. So yeah, we have to be very cognizant of that as well in terms of how we measure these things. I actually think cost benefit analyses might be a way to go, but done in using a health approach, not just an economic approach, but you can incorporate that. So I'm learning more and more about that as well. They're not easy to do, but that could be a step forward as well.
All right, I think that's all we have time for. Unless there is anyone else on the panel that has any final comments or would like to say anything in regards to the questions.
So before we finish up though, we'd like to thank someone who has helped put this together, and aside from obviously Juna, who's one of our key people at the Beacon, but Yudi, if you'd like to come forward. Yudi has been like amazing and has assisted with particularly the technology, which none of us are expert in. So thank you so much, Yudi, for all your help. Yeah, and Juno, you've been amazing as well in helping pull this together. And of course, Miriam and Mackenzie, who all help with the Beacon and work wonderfully together. But thank you so much to everyone. I don't know, Miriam, if you wanted to finish up.
Well, no, I mean, I think you said it perfectly. Thank you, Anne, online. Thank you to the panel. Thank you to everyone who organised it. Thank you for coming in person. It's always wonderful to see faces. And thank you everyone online. Apologies we didn't get to your questions. And thank you to catering. And we've got food for you. So yeah, please stay.
Thank you. Bye.
Thank you.